a plug for HERA's workshops on domestic violence. We have a series of 5 workshop domestic violence survivor series, including this one. So you see the list here: domestic violence survivors' rights in home ownership, the right to break a lease early, the right to change locks, rights regarding rent and utilities, and today's topic, the legal rights of survivors in public housing. So this is the agenda for this hour. We're going to talk about 3 main things. What is public and subsidized housing? What are survivors' rights in public housing? And then once you know the rights, what do you do with them? So first topic, what is public and subsidized housing? I'm going to do a quick overview of the housing programs that exist through housing and urban development. So all of these federal housing programs were established by the U.S. Housing Act of 1937 and the Housing and Community Development Act, HCDA. And those laws are found at 42 U.S. Code annotated sections 1427, et cetera, and 13,661 through 664. And those statutes are governed by the Code of Federal Regulations. You see the citation there, 24 Code of Federal Regulations, parts 3, 8, and 35. There are more, but those are the main ones that cover these federal housing programs. Most people are familiar with Section 8, also known as a housing choice voucher. And those are federal programs that are tenant-based rental assistance. And so under the Violence Against Women Act, which we will talk about a little further, VAWA is the acronym for Violence Against Women Act. And on each one of these housing programs, you're going to see in bold who is supposed to give you notice of VAWA rights. And so under the Section 8 Housing Choice Voucher Program, VAWA notice is supposed to be given to tenants by the Public Housing Authority that administers the Section 8 program. So your local housing authority is supposed to give notice of VAWA rights if you have a housing choice voucher. And that voucher is where HUD makes payments to the Public Housing Authority for low income tenant rent, and the tenant chooses where they live. And this also covers this is different from project-based vouchers, which are tied to the unit, not to the tenant. And this also covers Section 8 moderate rehab payments to public housing authorities for landlords to rent to low-income tenants. And so those are the basic provisions of the Section 8 voucher program, and VAWA notice is supposed to be given by the housing authority. When there's project-based voucher, that's the one that stays with the unit. Those VAWA notices are supposed to be given by the Public Housing Authority. That covers the Housing Choice Voucher Homeownership Program, where HUD funds other than moderate rehab, and those are not to be confused with project-based vouchers. Project-based housing is not to be confused with project-based vouchers. This next program, HUD-VASH, is a Veterans Administration Supplemental Housing Program, and those are vouchers only for veterans administered by the Veterans Affairs. And you would know if you have a HUD-VASH voucher, it combines rental assistance, case management, and VA clinical services for homeless veterans. And on those vouchers, VAWA notice is supposed to be given by the Veterans Association. I also want to make a note about non-citizens and immigrants immigrants, because under the housing and urban development regulations, people who are not citizens and who are immigrants are normally excluded from federal housing by Section 214, which says that federal housing benefits cannot be given to non-citizens. That's what Section 214 provides. And I do want to note that there are many exceptions to Section 214 for eligible non-citizens, those who have visas, DACA children, those with a green card. And so VAWA and the immigration laws give survivors of domestic violence immediate right to access public housing and benefits. And that's very important for immigrant survivors of domestic violence, be they male or female, that they can immediately seek safety through the public housing programs. And even if you don't have um, actual status through ICE, you may be able to get some protection in public housing. And also wanted to note that eligible survivors who have petitions for humanitarian asylum, special immigrant juvenile status, U visa, T trafficking visa for victims of trafficking, VAWA parallels the ICE system for protecting victims, and it says that a victim who is an immigrant can leave safely and get an application going for a green card to protect themselves. So that's a special protection for immigrants under VAWA. The next program is supportive housing for the elderly under Section 202 and disabled housing under Section 811. These are for nonprofit sponsors of housing for the elderly and disabled, and for construction and substantial rehab of housing. And on those types of housing programs, VAWA notices are required to be given by the nonprofit provider or whoever else is providing the housing. So it's not HUD and it's not the housing authority, but it's the sponsor of the nonprofit program who is required to give notice of your rights under VAWA. The same thing with Section 211 and Section 236. These are programs where landlords get below interest market rate 3% loans, and then they agree to rent to low and moderate income tenants. These are usually small multifamily or single family homes where the rent is regulated by HUD. And tenants in that housing are still entitled to notices under VAWA and the Fair Housing Act, the Federal Fair Housing Act. Tenants are supposed to be given notice of the Violence Against Women Act in the lease. So there's usually an addendum to the lease for that type of housing. Another federal housing program is housing opportunities for people with AIDS. It's called HOPWA, and then Native American housing. And that's where block grants are given to the states or local governments or nonprofits to have housing for those specialized groups of people. And in those cases, the housing provider, again, is the person who's required to notify you of your rights under VAWA. Your landlord might have layers of federal assistance. They might get a loan. They might also be giving out Section 8 vouchers. So if there are any combinations of federal assistance, the tenants in those units are eligible for the protections under VAWA. That includes the Housing Trust Fund, Home Rural Development, multifamily housing. These programs are designed to increase and preserve rental housing and home ownership for extremely low and very low income and homeless families. And the home investment are partnership programs for state and local governments to acquire, rehabilitate, and build new housing or sell or rent for and for-profit landlords who then provide tenant-based rental assistance. And it also applies to rural developments of multifamily homes. The McKinney-Vento programs are homeless assistance programs, supportive housing and services for the homeless in transition, and to try to help promote independent living. They also include the 3 homeless assistance programs that you may have heard of in California: Shelter Care Plus, there's the SRO, Section 8 moderate rehab, and supportive housing. And those 3 programs also are required to give notice to their tenants of the protections of the Violence Against Women Act. And so I say here, see the National Property Database, which is going to be given to you at the end of this presentation. You can put an address in the National Property Database to help identify your property, and it will tell you exactly what federal programs or federal credits the landlord, the owner of that property, receives. And if there are any, then federal laws apply, and the Violence Against Women Act and the Fair Housing Act give protections to survivors of violence. So the type of federal housing, this is a summary of what I just went over, determines who is required to give notice to the tenant. It could be the landlord in private housing. It could be the Public Housing Authority in Section 8 and other federal programs, or it could be the housing program or the nonprofit who is the provider. If you have a really old lease, it may be required to be amended under the law. VAWA was amended in 2022. And at this point in California, every new lease given after 2022 really must have a VAWA addendum attached to it in order for it to be considered a legal lease. So look out and see if your lease has a VAWA addendum attached to it. So next we're going to talk about what the rights are in these public and subsidized housing program. What does VAWA give the tenant? The Violence Against Women Act is found at 8 U.S. Code Section 1367, and it says that it is illegal for a covered housing provider to deny, terminate, or penalize any tenant who is a survivor of violence. And the definition of domestic violence, I'm not going to go into. There's a lot of training online that you can get that tell you who are the people governed by who are survivors. And actually survivors can be men or women. Even though it's called the Violence Against Women Act, it also applies to men, and it applies to survivors regardless of sex, gender identity, or sexual orientation. So transgender people also have rights to claim protection under the Violence Against Women Act. VAWA is intended to encourage survivors who live in public or subsidized housing to actually report it and seek help for the abuse against them without being afraid of being evicted. And that's why it's illegal to discriminate or retaliate against someone who has identified themselves as a survivor. And it also applies to those who are in the protected categories under the U.S. Constitution, the Fair Housing Act by extension. Applies to, there are many more categories in the U.S. Constitution and even more in the California Constitution that protect that have protected categories: race, class, gender, veteran status, age. And so the protected categories under the U.S. Constitution also apply in the Violence Against Women Act. And VAWA actually imposes some special duties on federal housing providers to protect victims, including public housing authorities, managers, landlords, housing organizations, and anyone else who received a federal subsidy, a tax credit, or any kind of federal housing benefit is required to enforce the Violence Against Women Act. So the rights, VAWA prevents a public housing authority or landlord from discriminating against, the T is missing on against, but against victims when they're renting the apartment. It also allows a tenant to move out of an apartment without a penalty, meaning break the lease. And we have a special webinar on breaking the lease. And also, this is important. If a victim is constantly calling the police, they cannot be evicted for making continual police reports. As a victim, you're entitled to call the police, and your landlord cannot try to enforce a nuisance clause or a conduct clause contained in the lease against you if you are a victim and you're calling the police, or your conduct somehow breaches the lease because of violence in your home. The Violence Against Women Act, as I said, prohibits discrimination. And it's important to note that an incident of domestic violence does not, under the lease, constitute a, quote, serious or repeated lease violation by the victim. And it also doesn't constitute, quote, good cause or just cause for eviction of that victim. You can evict the perpetrator, but you can't evict the victim. And a person also cannot be denied housing assistance through a housing authority based solely on the criminal activity that was the basis of the domestic violence, or because of their status as a survivor. And this is important because sometimes the victim is identified in police reports, and sometimes the police reports talk about mutual combat or conduct by both the victim and the perpetrator. And the survivor might sometimes have a criminal history that results from the violence in the household. But that doesn't mean that the landlord or the housing authority can screen you out based on that particular criminal activity that is a, quote, direct result of your status as a victim. So that's an important point to remember. And this act is very specific. That's why I started with who is supposed to give you notice, because you're entitled to receive written notice of the protections under VAWA, and your status as a survivor is supposed to remain confidential. This is important too, because landlords cannot go around telling tenants about another tenant in the building who's a victim. That should not be discussed with anyone. You're entitled to confidentiality if you are a survivor. And the Violence Against Women Act, VAWA, allows your housing provider, the housing authority or the landlord, to split your lease. If they want to keep the perpetrator as a tenant, they can give you, the survivor, a separate lease, and they can evict the abuser and allow the survivor to stay. So they can change the lease so that the survivor is the only person on the lease. And that tenant generally has at least 90 days to establish eligibility for that housing program, or to try to get help to port their voucher somewhere else, or to find some alternative housing that they are qualified for. So they get 3 whole months to try to do that after they have told the landlord they're a victim and they need to split the lease. It also requires you to have access as a victim to an emergency transfer plan. The housing authority can help develop a safety plan for a victim. You don't have to provide 30 days written notice to the landlord, and the housing authority has to help the victim to transfer their Section 8 voucher. It's called porting your voucher to a different housing authority, different county, or different building, so that you are safe. And those who are monolingual speakers of another language are required to receive VAWA notice in their language of origin. So if you speak Spanish, if you speak Russian, your lease must be given to you in Spanish or Russian. And the VAWA addendum that is attached to that lease must be in Spanish or Russian. And as a Spanish speaker, many tenants don't demand that their lease and all other notices be given to them in their language of origin. And as I mentioned earlier, it gives immigrant survivors immediate access to public housing and benefits. So, in order to obtain protection under VAWA, you do have to document the domestic violence. And so the survivor is the person under the 2022 amendments to VAWA. The survivor is the person who gets to choose the mechanism for notifying the housing provider or landlord that they are a victim. And any credible evidence is enough to prove. You don't have to have a police report. You do not have to have a restraining order, temporary or permanent. And you don't even have to have a statement from a victim service provider, a medical provider, a mental health provider, or even a service organization or, domestic violence counselor confirming that you had an incident of domestic violence. And you don't even have to have called the police or initiate legal proceedings against the abuser or perpetrator in order to declare yourself a victim of violence. That's an important point, because before 2022, victims had to go out and get some kind of document and submit that. Well, now you can self-certify. And so that's where we're getting to. What do you do? What practical remedies exist for you to exercise the rights that you have under VAWA? You're entitled to be safe in your tenancy. And so immediately, once you self-certify, and I'm going to talk about that certification in a minute, but once you do that, you then are entitled to work with the landlord or housing provider to improve the security of your unit if you do not want to move. And you do not have to necessarily move in order to protect yourself, but you simply submit a written request to the landlord asking for what you need to make yourself safer. The landlord has a duty to install high quality locks on the doors or windows, or to change the locks. If you feel that the perpetrator has a key and can get in, you can demand the landlord to change the locks. You can ask the landlord to install better lighting so that you feel safer going to your door and using your key. You can ask the landlord to trim shrubbery if there's bushes blocking your door that make you hide, that are places where someone could hide and attack you. You can actually ask them to trim the shrubbery to make it safe. And you can also ask your landlord or property owner to assist you with a safety or escape plan. All of that is required by the Violence Against Women Act. And I will be referring you to the HUD website where you can find the VAWA information. The Violence Against Women Act also addresses how to move safely if you are a survivor with a voucher. And so the housing authority must ensure that the survivor does not lose their housing assistance and does not lose their voucher. So they're supposed to help you maintain your voucher, and they're supposed to help move you to protect the health and safety of the victim and any children. And you can do it in violation of the lease if the victim reasonably believes that they are imminently threatened with future violence. And that's part of your declaration to self-certify. You say, I believe this person can attack me again, or I believe this person has a key to the gate of this building and can get in and attack me. And you can ask that the voucher be transferred to your name only if the perpetrator's name, if it's a multifamily voucher and the perpetrator's name is on the voucher, you get their name taken off. And the housing authority is supposed to help do that immediately. To keep your address confidential as a survivor, you can enroll in a confidential address or mail forwarding program. And you can obtain a post office box through California's Safe at Home program. I'm going to give you the reference to that at the end of this presentation. The California Secretary of State's website has a California Safe at Home link where survivors can get a confidential address to use on applications for anything going forward. Or a victim could list the address of a trusted friend or family member. You're even entitled as a survivor to write the word, quote, confidential, end quote, on the address line of a restraining order or application for housing in order to protect your address from the perpetrator. And when you ask for a restraining order, you can also ask the court to prohibit the abuser from trying to learn of your new address. In fact, the California Judicial Council forms for obtaining a restraining order actually have a box where you can just check the box to ask the court to include that order in your restraining order, that the abuser must not attempt to discover your address. That can be a violation of the restraining order and cause for law enforcement to arrest that person. And a landlord, as I said earlier, has to keep your status as a survivor confidential. Can't be going around telling people, oh, that person was beat up or that person is a victim. Can't do that. So the proof that is required to get legal protections, I'm not talking on this screen about self-certification yet, but a police report within the last 180 days does support proof that you are a survivor. If you got a restraining order within the last 180 days, if you have a letter from a qualified third party like a doctor, domestic violence counselor, therapist, confirming that you sought assistance for physical or mental injuries or abuse, that allows you to prove domestic violence status as a survivor. And there's an exception for survivors in this presentation for public and subsidized housing tenants. They only need to self-certify that they are victims in order to have proof to be protected by VAWA. So a survivor can't be evicted, like I said earlier, for making excessive police calls, and domestic violence is an absolute affirmative defense in an unlawful detainer action if the landlord is claiming just cause for eviction under Civil Code Section 1163.5, saying that the tenant has created a nuisance in the apartment building because there's domestic violence going on. And unless your HAP contract with your housing authority or some other document applies, all the landlord-tenant laws still must be followed by the federal housing provider. A couple of cautions. If you are a victim and you obtained a restraining order, do not violate the restraining order and let the abuser in, because then the landlord can give you a 3-day notice to evict you or cure or move that person out. And it's a problem for you to get a restraining order and then violate it yourself. You want to enforce it. And then the other caution is if the abuser was living with you in the apartment and wasn't even on the list, it could cause a problem for you with your landlord because that person could be considered an unauthorized tenant, and therefore you did violate the lease by allowing that person to move in the first place. So now there are some additional federal laws that protect survivors in housing aside from the Violence Against Women Act. The federal Fair Housing Act found at 42 U.S. Code Section 3601, also provides protections against housing discrimination based on the federally protected classes: race, color, religion, national origin, sex, sexual orientation, disability, familial status, or veteran status. And so all of those, you cannot be discriminated against on those, based on those characteristics. And you could say, as a survivor, that the landlord violated the Fair Housing Act because they only discriminated against you because, say, you were transgender and they didn't want to provide you VAWA protection. That's like a dual VAWA Housing Act case that you might be able to sue in federal court for. And then you have the right not to have your housing application denied because you're a survivor or because you have poor credit. This is important because we know in the field of domestic violence that there is financial abuse of victims, where people may hold on to someone's passport, may keep all the credit cards. They may not know anything about the finances of the house, and therefore, standing alone, the survivor has poor credit or has a poor rental history or has unpaid rent or utility debt, or they previously broke a lease because they're a survivor. If those things are all a direct result of domestic violence, then you cannot be denied an application for a federal housing program. And it's really important when you self-certify to say, this person was abusing me by keeping my passport or denying me any income, and I had to give all my money to him, or I gave all my money to her and she controlled all the finances. And so I don't have any credit, I don't have any rental history. You can still get into federal housing as a victim. So, what do you do about it if you were discriminated against based on survivor status? If you were denied housing by a federal housing program, you have the right to understand the basis for the denial and to ask for an explanation of the reason for denial from the housing provider. And if it's direct evidence of discrimination, you can sue through the housing authority. You can ask for, sue through housing and urban development and file a claim with the San Francisco regional office if you're in Northern California. And there are regional offices throughout the state of California and throughout the United States. Is there a policy that your landlord has that has a discriminatory effect and it doesn't have a substantial or legitimate non-discriminatory purpose? Then you might be able to sue the landlord over their policy that is discriminatory. And is it possible to have a less discriminatory policy where you don't discriminate against people who are victims? So that bears looking at what the basis for the denial of tenancy was. So here are the places where a person complains about VAWA violations. You could file a grievance with your local public housing authority office. The public housing authorities also have a procedure for informal review and hearing if regulations have been violated, or if a tenant claims that they were improperly denied admission to a federal housing program. And sometimes locally, there may be the opportunity for a public hearing before a rent board or before the board of supervisors. It really depends on where you live and whether there is a rent board in your county or city, and whether that rent board will hear these type of complaints. But ultimately, housing and urban development the field office in San Francisco, I mentioned before, for Northern California, and there's a field office in the Los Angeles area as well as San Diego. The Office of Fair Housing and Equal Opportunity, the FHEO office, is the place where a complaint can be filed administratively with Housing and Urban Development to complain about violations of the Violence Against Women Act or the Fair Housing Act. And you ultimately can file a private lawsuit in U.S. District Court, and you could include both state and federal claims in U.S. District Court under the Fair Housing Act of the federal government and also the California Fair Employment and Housing Act. We also have the California Unruh Civil Rights Act that prevents discrimination against people in certain categories. And so I could foresee a person filing a lawsuit for violation of VAWA under federal law, the Fair Housing Act under federal law, the California Fair Employment and Housing Act under California law, and the Unruh Civil Rights Act. So 4 different claims in one complaint in U.S. District Court for violation of the Violence Against Women, which would also involve some violations of the federal regulations that govern those housing programs. And so now, and that's where I discussed the federal lawsuit. A victim would have the right to ask for money compensation if they were the victim of discrimination, punitive damages to punish the person who did it, to stop them from doing that again to someone else, and then other types of relief that you might recover in a survivor civil lawsuit might include medical damages if you can prove that you went to therapy or you had some physical injuries that were caused because your VAWA rights were violated. And the Violence Against Women Act and the Fair Housing Act allow a prevailing party to recover their attorney's fees and costs. And that creates an incentive for lawyers to file lawsuits alleging violation of VAWA because they can then get paid by claiming the attorney's fees and costs for that suit. So this next slide is just about all the array of legal and financial counseling services that we provide at HERA. We do provide debt collection services in the areas of student loan, auto loan, medical debt, high cost loans or fraudulent loans, and homeowner association debts. We do credit reporting issues involving identity theft, accessing your credit report, or denial of credit because of a credit report or errors. We also look at financial products, mortgages. Our tenant team, which I'm on, and this presentation is from the tenant side, our pre-eviction concerns, harassment, fair housing, habitability, and debt and credit concerns for seeking housing. We also service veterans and service members and try to help with some estate planning issues that you see there. So if you need any of those services, please contact us for consultation with an attorney. And at this point now, we have about 15 minutes to open it up if there are any questions that the audience has. Let me see if there are any. I don't see, let's see. Let me just remind you to complete the survey. You'll see the Survey Monkey there, the survey form in the chat box. We're asking you to click on that and let us know what you thought of this presentation. It'll help us for future presentations and also for our grant writing purposes. The California Safe at Home program, I see that Michael Sun, I think, is my assistant who put that link into the chat box, www.sos.ca.gov, registries, and then you click on Safe-Home, and you'll get to that Safe at Home page that will tell you how to get a confidential P.O. box to use instead of your real address as a victim. And once again, any questions out there? I'll wait a few minutes. If anyone wants to type a question in the chat box, I'd be happy to answer any. It looks like we had 12 of you participating today, and I hope that this information was helpful to you. And again, you can contact HERA if you are a victim and you want to discuss your personal details with an attorney. We do give an hour-long free consultation, and all of HERA's services are free of charge. We try to service extremely low, and moderately low income or moderate income people. And so call us if you have issues that in the areas I described. So thank you for your time and attention. We appreciate you coming, and look for you next month when the library will be presenting another webinar from HERA in the Ask a Lawyer series. Have a great evening, everyone. Have a great afternoon, and see you soon. Thanks for your attention.